You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 43, How to Read and Understand an Office Action. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondspatentlaw.com. That's DIAMENT, patentlaw.com. Or if that's too hard to remember, you can get through it by typing in patentingforinventors.com. That's patentingforinventors.com. Or you can call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state, so feel free to contact me regardless of where you live. In the last two episodes, I talked about objections and rejections. So how do you know if you get a rejection or objection? You'll get a letter from the patent examiner listing the objections and rejections and the reasons why your application has been objected to or rejected. This type of correspondence is called an office action, or the first office action on the merits. Now, you may get some other correspondence first before you get your first office action on the merits. You may get something saying that your declaration wasn't done right, or you didn't fill out some other type of form right, or pages were missing, or maybe you'll get what's called a restriction requirement, which I'll cover in another episode. And that's basically when the examiner thinks that your application has more than one invention, and you have to pick one invention for the examiner to file. These types of correspondences aren't considered things that have to do with the merits of your invention. So what does an office action look like? It's a letter from the patent office that has different parts. On the first page, you'll see some information about your application, the application number, the filing date, the inventor's name, the examiner's name, the art unit, and notification date. The notification date is important, which I'll go over soon. The next page of the correspondence will have a summary. The top will have the period to reply. This is really important and should be the first thing you do when you get an office action, which is to write down that date. Most types of rejections and objections, you'll get 3 months to respond to. You'll see that it says there's a shortened statutory period to reply in 3 months from the mailing. It says shortened statutory because you actually have 6 months to reply. You'll see in small print below, the part that says 3 months, that you can get an extension for a total of 6 months from the mailing date. So what this means is that if you file within 3 months, you don't have to pay any fees to the patent officer responding. You can file up to 3 months later if you pay the patent office some fees. Each month you're late, you'll have additional fees. So there's a 1-month extension fee, a 2-month extension fee, and a 3-month extension fee. Here's an example. Let's say you get your first office action on January 1st, 2018. If you file your response on or before April 1st, that's 3 months, you don't need to pay any extra fees. If you file between April 2nd and May 1st, you have to pay a 1-month extension fee. If you file your response between May 2nd and June 1st, then you have to pay the 2-month extension fee. If you file between June 2nd and July 1st, then you have to pay a 3-month extension fee. If that date lands on a weekend or holiday, you get to file the day after the weekend or holiday without having to pay the next month's extension fee. You can look up the cost for each month of extensions on the Patent Office website, and the fee goes up each month, and the fee also depends on your filing status, whether you're a micro, small, or large entity. For the first month, it's either $50, $100, or $200, depending on your status. For the second month, it's $150, $300, or $600. And for the third month, it's $350, $700, or $1,400, depending on your status. These prices do go up occasionally, so always check the latest fee schedule at the Patent Office for the correct fees. There are some types of scenarios where you can get more time and get 5 months extension, but for most of your office actions, this 3-month and 6-month rule applies, so mark those dates down. If you don't file anything by the 6-month mark, your application goes abandoned. You can revive it, but it costs a lot of money, and there could be issues with that later down the road. But I'll have a whole episode on patent application revivals later. The next section is the status section. The most important part is probably going to be the boxes in 2A. There will be a box saying this action is final, and in box 2B, it says that this action is not final. The first rejection you get is going to have the box that says non-final. What this means is that you can respond to the rejection without doing anything special, just a normal response. But since I haven't talked about responses yet, you don't really know what normal is or what a special response is. But basically, when you write a response, you're going to say, response to non-final office action, and you make your arguments about why your claims should be allowed. What happens is that if you get a second rejection, most of the time that's called a final office action. Don't worry yet about it saying final. It doesn't mean that your application is rejected forever and there's nothing you can do about it. There are lots of things you can do when you get a final office action, probably about 6 or 7 things to keep your application going if you get a final office action. And oftentimes, depending on the situation, it might just mean you'll have to pay some more money to the patent office to get them to keep examining it. That's not always the situation, but it's an option. I'll cover the options of what to do if you get a final office action in later episodes, but for now, your first office action should say non-final. The next section says disposition of claims, and there will be some boxes about what the examiner thinks of your claims. It will say which claims are pending in your application, which are withdrawn, which claims are allowed, rejected, or objected to, and which claims have to be split up because they cover more than one invention. Hopefully you have at least some claims allowed, but maybe not, and that's fine. We can deal with that later. The next section says application papers. This has a couple boxes saying whether the specification and drawings are okay. The specification is the written description, and any issues with that probably will have to do with making sure that you include all the parts like the abstract and things like that. The drawings may have objections because maybe you forgot to include some reference numbers, but it could be a lot of these things. All these things will be explained in detail by the examiner in the later parts, but these first pages are just a summary of what the details are going to discuss. The next section says priority under 35 U.S.C. 119. If the current application claims priority to another application, it will list whether the patent office has received the priority application. Maybe this application is a national stage of a PCT application, or it started from an application in a foreign country, and the patent office is telling you that it has received the original application as well. Hopefully it's received if you have some other application that you've done before this, but if not, then you have to do some things to make sure the priority document gets to the patent office. That can get a little more complicated if you have to do that, but I just want you to be aware of what this section is. The next section is attachments, and it will say if there are any attached documents to the office action. It may be a notice of references cited, the information disclosure statement, an interview summary if one has happened, or something like that. The rest of the office action is going to be the details about everything that was listed on the summary page. It will say what the objections are, or why the application has been rejected. It could be 2 pages, it could be 50 pages. I'd say typically it might be around 10 pages double-spaced, but it really depends on all the reasons why your application has not been allowed yet. There'll be some other documents in there. One is a document showing all the terms that the examiner has used in the search, so you can see how the examiner looked for similar things to your invention. In the office action itself, the examiner will say which inventions, called prior art, the examiner is using to reject your application. Generally, the examiner isn't going to give you the actual references, unless it's something foreign or not something you can get from the U.S. Patent Office. So what you should do when you get an office action, and I think one of the first things that you should do, is do a patent search for the references that the examiner listed, and make a folder called References or Prior Art on your computer. Put all those prior art references that the examiner used to reject your application into a single folder, because you're probably going to be using these references in your response. I like to open these up in Adobe and OCR them, so I can do text searches within the document, so I can prepare my response. There are all sorts of other things you need to do in order to prepare an office action, but in this episode, I just wanted it to be an introduction of how to read the office action and what to do when you get one. Calendar at least 3 and 6 months dates for deadlines, and you can also calendar intermediate 4 and 5 months deadlines, so you can have on your calendar when the different monthly extension fees kick in. Also check the status of your claims to see what's rejected or objected to and what's allowed. And that's pretty much for the bare bone basics of how to read and understand an office action. I can't go super detailed in a single episode because every application is going to be rejected for a different reason. I covered what these reasons could be in the last 2 episodes about objections and rejections, but there could be a whole lot of reasons, and we'll go into some details later about specific types of objections and rejections and how to respond to them. If you want help with drafting your patent application or help responding to an office action, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.